Housing rights in England go back a long way. As we can see here, here's a quote going back from the 19th century. And it's quite interesting. It says, "The poorest man may, in his cottage, bid defiance to all forces of the crown," crown being, as you all know, the king or queen. "It may be frail, its roof may shake, the wind may blow through it, the storm may enter, the rain may enter, but the King of England cannot enter. All his force dare not cross the threshold of the ruined tenement." So as you can see straight away, there's a classic English tradition at work that the law will prevent anybody, including the king, from entering anybody's home, but there's zero chance of getting any repairs done. So I'm going to say very little, if I can, about black letter law in England, but it would be quite wrong not to say something about what we've done with the Human Rights Act. In our traditional non-arrogant fashion, in the late 1990s, we decided to bring rights home, because, of course, we invented human rights, as you all recall. And we did that by enacting the Human Rights Act 1998, which brought the European Convention directly into force in English courts. And the pivotal, if you like, provision in that Act really is Section 6, which I've put up there, which says, Acts of public authorities, subsection 1, it is unlawful for a public authority to act in a way which is incompatible with a convention right. So a pretty strong, broad duty, qualified, of course, by subsection 2, which says that any public authority has an absolute defence, in effect, if the actions that they're taking are required of them by primary legislation. What if that happens? Well, then we have section 4, which permits the court, if it thinks that primary legislation is incompatible with a convention right, to declare as much, to make a declaration of incompatibility. And any of you who are remotely interested in how the English legal system works and the supremacy of Parliament will note subsection 6, which I put there, which says, a declaration of incompatibility has no legal effect whatsoever. In other words, the law which is declared to be incompatible is still the law and must be applied until Parliament takes it upon itself to change the law if it so wishes. So those are the basic provisions. That's all I'm going to say about any particular statute in this country, but it's just important to understand how human rights fit in to the English legal system. Oh, I forgot, of course, Section 2, what has turned out to be possibly the most controversial provision in the Act, bizarrely enough, because it says very little. As you see there, it says, interpretation of convention rights. A court or tribunal determining a question which has arisen in connection with a convention right must take into account any judgment, decision, declaration or advisory opinion of the European Court. I mean, would it really have been necessary to say as much? Would it really be likely that the English courts wouldn't take into account the decisions of the European Court? Well, we'll look a little bit later about how the courts have used that particular provision, a provision which is directly under attack by our current government, and I'll come back to that, if I may, in a little while. So which rights are we interested in when we're looking at housing? Well, of course, the first one is protection of property. We're English lawyers, after all. Article 1, Protocol 1, you're all aware of that. I'm not going to read it out, but you know essentially what it does. It protects existing property or future rights to existing property. No surprises what the other one is. Article 8. Now, just for a moment, I'd just like you to imagine that you're an English judge who's not much impressed by human rights law so far, because, of course, we invented it, and we really didn't need to be reminded of that by our Parliament, because it was our judges who invented it, of course, to some extent. And they look at Article 8, and later on down the line, they're going to be asked about what relevance this has to housing rights. And it says, everyone has the right to respect for his private and family life, and, by the way, his home and his correspondence. So number 3 in the list, and it's only a respect for in any event. And of course, as you all know, Article 8.2 then qualifies that right in any event, and I'll come back to that again in a moment. So those are the 2 rights that we're primarily interested in. So what's in scope? What have the courts shaved off right from the outset? Well, as we all know, there is no right to a home under the European Convention of Human Rights, and the English courts have not interpreted Article 8 in any different way. And from one perspective, that could be the end of the talk, frankly. There's no right to a home. That's not going to change either now or in the near future until we see some new human rights enacted. And that's subject to an entirely separate talk, which I would be far more happy to give. Anyway. However, one piece of judicial intervention which has got plaudits all around the world, especially in liberalised democratic countries which aren't particularly fond of positive obligations, is a case called Limbuela. Just to say something very quickly about Limbuela, the government thought it was necessary because we had so many people coming into Britain to apply for asylum. I mean, like so many, like almost like, I don't know, a couple of 100,000 or something like that. Absolutely nothing compared to most of our European partners, but there we are. That we decided that it was completely inappropriate to have all of these people come into our shores, make their applications, and whilst waiting for a decision on their application for asylum, to receive any kind of state benefits. So you're thinking, right, well, obviously you kind of gave them the right to work then, right, so that they could support themselves and their families. Oh, no, no, they weren't allowed to work either. So this form of state-sponsored destitution came up before the court. And the government's position literally was that for a certain subset of asylum seekers, and I won't bore you with the details, but essentially those who came into the country on false passports, so namely basically all of them, because I don't know if you're applying for asylum from a country where you feel you're being persecuted and you turn up with your ordinary passport, i.e. not a fake British passport, and say to the authorities in the country that you're seeking to leave, I just want to pop over to Britain to apply for asylum. Is that all right? Unlikely to happen. So hence there's an entire industry built around false passports, which is how people get into Britain in order to apply for asylum. But the government thought that this was obviously dishonourable from the outset and prevented these people from applying for any benefits. So Limbuela was a really key decision because what did the court do? They didn't look to Article 8, incidentally. They looked at Article 3, the prohibition on inhuman or degrading treatment, and said state-sponsored destitution, which is my term, by the way, not one the court used, is unlawful because it basically subjects people to that type of treatment. That's about as far as it gets in terms of positive obligations and a right to shelter in the UK. Again, that may have been a convenient place for this talk to stop, but we'll continue a little longer. Martin has said something about Part 7 of the Housing Act 1996. It would be quite wrong of me, when giving this description of English law and human rights, to ignore the fact that we do have significant duties on local authorities to accommodate people who are homeless and who are in priority need. The key issues being whether or not they caused their own homelessness and whether or not they have a particular need which is, if you like, exacerbates the state of homelessness over and above the ordinary person. But quite a large number of people do qualify. For example, if you have children, you have a priority need. So that's what's in scope. Horizontality. Well, I think you probably all know what that means. That means this. Does Article 8, or indeed any of these human rights, have any effect in a horizontal way? In other words, in circumstances where it's a dispute between two private parties, a dispute, for example, between a private landlord and his or her tenant. Well, the answer is quite clearly no. And the reason why it's a no is because if you remember Section 6, the duty I showed you right at the beginning, that duty only applies to public authorities. And private landlords are, of course, not public authorities. So in that sense, you think, well, not particularly controversial. I guess there's not much we can do about that. A little insight into our means of prioritising issues in England comes from the observation that Article 1, Protocol 1 rights, i.e. the right to your possessions or peaceful enjoyment of your possessions, is indeed applied in a horizontal way, so that business tenants can invoke Article 1, Protocol 1 against their private landlords. And the mechanism by which the courts have managed to achieve that result is to say, well, we as the court, of course, is a public authority. We are, of course, therefore subject to the duty to act compatibly with human rights. And therefore we cannot allow a state of affairs to continue. We cannot sanction, if you like, we cannot condone a state of affairs where we consider there would be a breach. Completely arbitrary distinction. There's no reason at all why the same logic couldn't be applied to tenants of private landlords so that they could invoke Article 8 or indeed any other rights. And the European Court has, in a couple of decisions, got somewhere close to saying something like that. And I've listed them both there, Beltikova versus Russia and Kurshad versus Sweden. I won't go into the facts. They're not entirely unequivocal about the issue, but there are the beginnings, or the noises, if you like, of horizontal effect for human rights. And indeed, Lady Justice Arden, who's not the most progressive judge in England, to be fair, recently made a decision where, although she found against the private tenant of a landlord, she did suggest that a case of that nature might soon be suitable for consideration by the Supreme Court to see whether or not there should be some horizontal effect for human rights. So that would be a definite positive, I think. The compensatory factor is the courts have taken a reasonably broad view or approach to the question of what is a public authority when it comes to landlords. So as Martin very usefully described, it's no longer the case that all social housing in Britain is provided by local authorities, i.e. manifestations of the state in a direct sense. Most of it, or at least about half of it now, I think, if I understood correctly, is now provided by what we describe as registered social landlords, who enjoy to a greater or lesser extent some public benefit, if not direct public subsidy. And the courts at the moment haven't said that they're all public authorities, but they've certainly opened their mind to the possibility that some of them might be, and that arose from the case of Weaver and London and Quadrant. So A1P1 is of limited interest, we can say right at the outset. Whether that ought to be the case is another matter, but at the moment A1P1 only concerns, as I said, existing property rights, and at the moment at least it is not considered to be a solid foundation for the creation of new property rights, or essentially new property rights. And I've got a quote there from Lord Scott in a very famous case in this context of Kazi, where he says, Article 8 cannot be read as authorising any deprivation of the property rights of others. So not only is A1P1 not used to establish new property rights, the English jurisprudence very firmly sets property rights as being in a privileged state. And as Professor Kenner explained in his opening remarks yesterday, it might be said that the high esteem or privileged status that's given to property rights has been one of the chief obstacles to the creation of a human right to housing or something of that ilk. So what's left? No right to a home, no horizontal effect. Therefore, the focus has been on protecting tenants of social landlords from eviction. But again, Lord Scott, in the case of Kazi, had something to say about that right at the outset. Article 8 was intended to deal with the arbitrary intrusion by the state or public authorities into a citizen's home life. It was not intended to operate as an amendment, not an amendment, or improvement of whatever social housing legislation the state has chosen to enact. There is nothing on Strasbourg case law to suggest the contrary. Fundamentally, that's probably correct. Article 8 doesn't imply a right to a home. But what has happened is there's been some toing and froing about the precise parameters of conventional property or contract law and the effect that Article 8 has or has not had on that. Just got to say something very quickly before I go on to look at the cases on this about what the status of social housing in the UK is. And Martin has done some of this job for me, so I'll move through this quite swiftly. Just want you to keep some key concepts in mind, however. So the gold standard are secure or assured tenancies, which are basically indefinite in length and actually often include the rights to succession for family members or spouses. They can only be terminated on specified grounds and if the court considers it reasonable to make a possession order. So it's very much in the hands of the court as to whether or not somebody loses their secure tenancy. And one has full due process, so the court hears evidence in the normal way and reaches its own view. So that's the good. This is the bad. The lesser form of secure tenancy is an introductory or a probationary tenancy. It comes in various forms, I won't bore you with the details, but in effect what they are 12-month tenancies which can be converted into a secure tenancy if the tenant behaves themselves essentially in the meantime. They can be determined, however, by the local authority or the social landlord, whichever it is, within the initial 12-month period on no particular specified grounds. It's a very broad discretion. There are limited rights available to the tenant, namely the right to request an internal review. So that's the same landlord making another decision, but more often by a slightly more senior officer, as to whether or not the tenancy ought to be brought to an end. There are some notice requirements, i.e. one has to have essentially 4 weeks' notice, and the court can check whether or not all of that has been done, but otherwise has absolutely no discretion as to whether or not the tenancy ought to come to an end. There is no reasonableness requirement, but there is, as a last resort, the concept of judicial review, and I'm going to come back to that in a moment. So I hope you see quite quickly there is very clear demarcation between the gold standard and the bad. Non-secure tenancies, are another form of the bad. Those are the tenancies we provide under Part 7 of the Housing Act that I mentioned earlier, which go to people in priority need who are unintentionally homeless as a temporary measure until they manage to obtain indefinite accommodation. And when I say temporary, it can be anything up to 7, 8 or 9 years. And during that entire time, they live under an entirely insecure status. Not the ugly, but the disgraceful. Are gypsies and squatters. No private law rights at all. Only due process is that they cannot be evicted without a court order, for the most part. And again, the last form of resort is judicial review. What is judicial review? Well, it's extremely limited in the conventional sense. First of all, the court must proceed on the basis that the landlord's version of the facts is correct. So under judicial review, there is no right to hear evidence. The court doesn't investigate facts. It doesn't ask people to tell them whether or not they're telling the truth or not. It simply has to accept the public authority's version of events. So that's obstacle number one. There are only limited grounds to challenge a decision to evict somebody under judicial review, and they are essentially entirely process-orientated. In effect, did the decision maker have regard to all relevant material considerations? Or did they have regard to irrelevant considerations? The other possibility is where there is a serious procedural failure, i.e. bad faith, or very serious bias, not just the obvious bias of the landlord being its own judge as to whether or not a tenancy ought to be terminated, but something much more clear-cut than that. For example, the individual decision maker has some sort of gripe against the individual tenant. And three, something that has many different names, often called regulatory unreasonableness or irrationality. I prefer the true word, which is perversity. And I've just quoted there just so you can have a flavour of what kind of test that involves. So absurd that no sensible person could ever dream that it lay within the powers of the authority. Outrageous in its defiance of logic or of accepted moral standards. Taking leave of one's senses. Unreasonableness verging on an absurdity. A pretty high test. Much, much higher than, taking everything into account, is it really reasonable that this person ought to be evicted? Or the last one's quite good, as an example, to dismiss a red-haired teacher because of the colour of her hair. Ignoring discrimination arguments for a moment. That's the best the judges could come up with as an example of what might be outrageous in its defiance of logic or of accepted moral standards. So I hope you all see that that is an incredibly high threshold for a tenant to overcome who's unhappy with a decision by his landlord to bring his tenancy to an end. So what does Article 8 have to offer to this process? Well, of course, first of all, it's a qualified right, as we saw. It's not an absolute right. It requires a balance to be struck between competing interests. There is always a margin of appreciation to be afforded to decision makers, and indeed in Strasbourg, of course, the court affords a margin of appreciation to the states themselves. And it involves highly political questions involving issues of social policy. And for the most part, that's true. As Martin has just explained, the history of housing law in the UK is controversial, is political, and does involve a number of very difficult considerations. So the test that the courts have developed in relation to Article 8 is a fairly strict one, however, because as we saw under subsection 2, any interference with the right to respect for your home must be necessary in a democratic society. And that test applies to all countries which have incorporated the Convention. And that is where the concept of proportionality arises. In order to judge whether or not a particular measure or interference is necessary in a democratic society, we must ask whether or not it's proportionate. And the best four-stage test we have on that comes from the case of Huang, where it's, as you can see there, is the legislative objective sufficiently important to justify limiting a fundamental right? Are the measures which have been designed to meet it rationally connected to it? Are they no more than unnecessary to accomplish it? I.e., is an eviction the only solution to the particular problem you're having with a tenant who's not paying his rent, for example? Do they strike a fair balance between the rights of the individual and the interests of the community? So, two bum ideas developed by our judiciary in the first instance. First of all, when it comes to the eviction of somebody from social housing, is Article 8 even engaged in the first instance? Does an eviction in any way constitute a lack of respect for somebody's right to their home? Speaking from this position now, the answer seems so obvious, the question itself seems ludicrous. But believe me, at one point, that wasn't the case at all. It was very seriously argued that there can be no prima facie breach because when the tenant took the tenancy in the first place, he or she knew what the limits of his or her rights were. And so the mere fact that those rights have not been, your tenancy has been determined in accordance with those rights, implies no lack of respect at all. Thankfully, that idea has not prevailed, and the concept of one's home is now very firmly considered to be an autonomous subject. I'm sure Lorna will say more about that later. So, in other words, the court determines whether or not a particular place is one's home without regard to domestic law and the extent to which it gives you any right of ownership or prescribes in any way whether or not it should be considered your home or not. That was bum idea number one. Bum idea number two was, all right, fair enough, Article 8 is engaged and prima facie there's a breach where somebody's going to be evicted. But Parliament has devised these particular schemes, like, for example, the introductory scheme we looked at a moment ago. Therefore, Parliament has assessed what the correct balance ought to be, and Parliament has said that it's fair. And therefore, in other words, Article 8 can never be used in any conceivable way to defeat an otherwise well-made out contractual or proprietary right to possession. In other words, it completely gutted Article 8 of any serious relevance to English housing law. So you've all been waiting for me to discuss ping pong. How could one ignore table tennis if one's talking about housing rights in England? That has become the conventional metaphor for describing what happened after Kazi, which was an almighty match between the European Court and the English Supreme Court, or House of Lords as it was originally called. Over about 10-11 years, they played up to 6 sets of pretty fierce ping-pong. Kazi was the first, as we saw a moment ago, and Article 8, as we said, was not engaged. And just to give you some very brief facts about these cases, and I'm going to keep this very, very brief, Kazi was a case about where a husband and wife had separated and they had a joint tenancy, and under English property law, once one of the joint tenants determines that joint tenancy, that determines the rights of both tenants, in effect. And so the landlord was able to turn around and say, well, I'm afraid that your wife has left, Mr. Kazi, that's brought your tenancy to an end, we'll have your property back. Connors versus UK was actually slightly predated Kazi, although nobody had noticed. And Connors versus UK was a decision of the European Court which said, in relation to gypsies, which as we looked at a moment ago were part of the disgraceful group, had no right at all to ask any independent and impartial court to question the proportionality or otherwise of their proposed eviction from some land. Land, in fact, that they'd been on for some time. That directly contradicted what was said in Kazi, which was, in effect, the court had no role to play. Kay versus Lambeth was the next decision of the House of Lords, and that concerned short-life occupiers. So that's situations which would otherwise be clear incidents of secure tenancies, but where the particular local authority landlord indicated that it wished to develop the land at some point in the future and therefore used a clever legal device to ensure that they only gave short-term or short-life accommodation to those tenants. Some 20 years later, when they finally decided they wanted those short-term tenancies to come to an end, unsurprisingly, the tenants turned around and said, well, come off it. You said short life as in like a couple of months. This is 20 years later. This is my home now. I want to be able to ask the court to assess whether or not it really is necessary in a democratic society for you to take these properties back. And the House of Lords said, I don't think so. But we have got this difficult decision of Connors. So I guess what we'll say is this. We'll say, well, if you can challenge the entire system and say the entire system breaches Article 8, a macro challenge, as some people have described it, then go ahead, you can try that. What was that? Nothing to say much about that? Okay, so they were in no position seriously to challenge the entire, if you like, English property law system, which was behind the device that had been used by the landlord to ensure there was no security of tenure. The second one was, well, you can always use traditional judicial review. And they were like, well, we knew that anyway. We didn't need Article 8 to tell us that. And that was equally of no avail to them. So at the moment it's 2-1 to the House of Lords. McCann versus UK was quickly followed from that, and that's where the European Court had a very similar case to Kazi, where it was a husband who'd lost his right of tenure when his ex-wife had terminated their tenancy, although the slight difference in this case was there were two facts. One, there was an allegation that the husband had committed domestic violence against his wife, and secondly, there was a quite serious, allegation, I'm going too fast, that in fact the landlord had, if you like, solicited the decision of the wife to bring the tenancy to an end, which therefore brought the interest of the husband to an end. So that was another case of the European Court which said, well, look, you really have to give the court some right, some ability to assess proportionality for itself. You can't leave it all up to these registered social landlords or local authorities to make decisions in their own cause. So then we had Doherty versus Birmingham, and that was when the English courts really started to be on the back foot, because the tide of European court decisions against them was really growing. And this is also where we saw the English judiciary get in enormous fuddle. The first thing they did is say, well, look, this is so complicated, we'll have more judges. So they did something which was very unusual, and they had 7 judges sit rather than 5, which is really, it's only happened about 3 times in the time I've been practicing. And all 7 judges managed to come up with a completely different way of trying to navigate their way through all of these conflicting decisions between the European Court. And you'll remember that Section 2 of the Human Rights Act only required them to have regard to the decisions of the European Court. They weren't in any way bound by them. But they also knew that if they got it wrong, the lawyers for Mr. Doherty would be straight off to the European Court, and the European Court would simply be embarrassing them yet again with yet another decision suggesting that they'd misunderstood the fundamental human right to respect for one's home. So in that case, they said, all right, well, it's still the same. You can do your macro challenge to the whole legal system altogether, which is obviously hopelessly impossible. Or you can have judicial review, which of course you had anyway, so we're giving you nothing there. But when we looked at the grounds of judicial review, and we saw that they were very narrow, they decided that they'd try and expand the notion of judicial review to include wider considerations, without a clue as to what that meant. And effectively, nobody knew what it meant. Then there was some discussion about whether the wider considerations could include the personal circumstances of the tenant. So prior thereto, they were operating on the basis that the personal circumstances of the tenant weren't relevant to whether or not their human rights had been breached. If you can work that one out, nobody else could. Including the European Court, who then looked at the issue again. This time in a previous case, the House of Lords had looked at K versus the UK, where, to be fair, they didn't find there was a breach, but they did comment on the pleasing nature of the fact that the English court was starting to move in its direction, which they welcomed, rather, I might say, somewhat patronising judgment, at least it was perceived to be by the English court. So that was set 2, game, set, and match. Eventually, the English court gave in and took a completely different approach. A new Lord who hadn't pronounced on any decisions before was given the right to give a single judgment on behalf of all of the judges in Manchester and Pinnock. And there's a little bit of note there. They couldn't quite say that they were bound to follow the decisions of the European Court, but they were at least prepared to say what I've underlined there, that if there is a clear and constant line of decisions, whose effect is not inconsistent with some fundamental substantive or procedural aspect of our law. Well, it self-evidently was, but anyway. And whose reasoning does not appear to overlook or misunderstand some argument, i.e. they're not just being a bit stupid, we consider that it would be wrong for this court not to follow that line. And Lord Neuberger most plainly ought to have been a diplomat in a different life. But the result was this, and quite straightforward. Where it is required in order to give effect to an occupier's Article 8 Convention rights, the court's powers of review can, in an appropriate case, extend to reconsidering for itself the facts found by a local authority, or indeed to considering facts which have arisen since the issue of proceedings by hearing evidence informing its own view. That's the gold standard, isn't it? The court get to decide, the court get to hear evidence, the court get to interrogate witnesses, and the court decides whether or not it's a breach of Article 8 or not for an eviction to go ahead. In one decision, have they not just elevated the bad and the disgraceful up to the standard of the gold standard? In other words, is this not the judiciary legislating? Is this not the judiciary expanding social housing for a class of people beyond that which Parliament had previously legislated for? Well, that's certainly one interpretation that an awful lot of people came to when they first saw the decision. However, in the very same decision, the court was very quick to try and dampen such expectations. And here we see at paragraph 54 the primacy of property rights rearing their ugly head again. Because even though the courts now have the right to make the decision, they've fettered that discretion quite considerably at the outset by recognising in effect the primacy of property law. Therefore, in virtually every case where a residential occupier has no contractual or statutory protection and the local authority is entitled to possession as a matter of domestic law, there will be a very strong case for saying that making an order for possession would be proportionate. However, in some cases there may be factors which would tell the other way. Oh, sorry, okay, I'm going to just finish then. So what they're doing once again is vindicating property rights, and just very quickly, I've got two more slides. The glimmer of hope was paragraph 64, where in response to a submission by the EHRC, they made it clear that in respect of occupants who are vulnerable as a result of mental illness, physical or learning disability, poor health or frailty, and that the issue may also require the local authority to explain why they are not securing accommodation in such cases, seemed to us to be well made. So in other words, what they were saying is one consideration might be if you've got a particularly vulnerable tenant, what's going to happen to them thereafter? Not exactly rocket science. One particular case that soon came after that was Corby and Scott, and that was a woman who had a non-secure tenancy. She was brought to court for rent arrears. Just before the hearing, she paid all those rent arrears off and also explained to the court that she'd just been the subject of a vicious attempted murder, and she asked for the court to take that into account when assessing whether or not it was proportionate to evict her. Before the lower court judge, she was successful. Before Lord Neuberger, the very same judge that gave the single decision in Pinnock, he said that those facts got nowhere near justifying the contention that it would be disproportionate for the local authority to obtain possession of her flat. So there it is in the language, nowhere near, when she paid off the rent arrears that were the reason she was in court in the first place and had been subjected to this terrible attack. So we see there very clearly what all of this has achieved, which is that property rights still reign supreme. Two quick issues then to be careful about. We've actually lost some of the merit in judicial review because the courts are now saying that because the court gets to make the decision, even if there have been some defects in the decision-making process, as we highlighted earlier under judicial review, the court themselves can cure it by looking at the ultimate result and making a decision itself as to whether or not it's proportionate. In other words, this has all backfired on us because the courts have now robbed us of the procedural rights we did have and given themselves carte blanche to reach the sorts of decisions that we just saw in Corby. Second, the existence of proportionality has now been used by the government to justify the end of the gold standard. In other words, we no longer are going to have secure tenancies which last indefinitely because the courts have got the right to assess whether or not bringing those tenancies to an end as a matter of right is proportionate. So again, things appear to have somewhat backfired on us. I have to just finish on this slide because one very important thing that's happening in Britain right now is this government is trying to rid ourselves of the Human Rights Act. And I recently actually found out that I've got Irish blood, which I didn't know until about 2 weeks ago. So my fellow Irishman here gives a very eloquent statement there as to why that would be a disaster for Britain, particularly those who are interested in the progressive development of rights. It's also a great relief to me to find out I had Irish blood, because it finally explained why I always found it so easy to drink my English counterparts under the table. Anyway, so thank you very much for listening.